On the bench.
I'm sure it's really fun. Well, how are you? Good. Glad you could make this. Yes. This will be fun. We haven't been, but we got along with the yeah, I saw you. So our firm represents Everytown. You've been representing them for probably 3 years. Yeah. Mostly moving with carry cases, other cases as well. Yeah, you guys are working. Yeah. I remember I saw you. It's a gross number. That's a good number. Right. John was there. And Bill was there too. Yes. I went there. I've seen you in action. Are you now? Are you representing parties? That's right. I've done. I think you did another too. Oh yeah. So you argued that before Kavanaugh. Oh yeah. It was a great argument. I mean, Ginsburg. This issue she always holds the other. I noticed that she didn't grant any grades. She was a little bit color 3 years. She was on that round. In fact, she descended from the 4th base that they sell. So registration. They canceled the registration on that is the other. So say after what's happened in the past, but like since there's some music and set, we're comfortable with everything you need. Good chance to grab right. These interrogation lights. For the cameras. Yeah. I'm sure it's not the speaker. My first year in undergrad, I was kind of nice for on a stage. You just can't see anything. But for speaking purposes, when you want to make eye contact, it's kind of survey that you're going to do that. Not a benefit. Are you having fun with them? You guys are next meeting. Really interesting colleagues. It's very hardcore, and it's collegial, which was not old generation. Yeah. Good job. Yeah, exactly. But anyway, Paul Logan spoke at a conference for DC conference. And he was talking about how Logan decided. Hey, Stephen.
Okay, I'm Mark Smith, by the way. Sorry we're not debating, but maybe down the road. Can we talk for a second?
So yes, like don't do it again.
Yeah, I think
you already did it once.
That was my understanding of how the decision was made.
Yeah.
Do you know what modifications have been made by this PC in the wake of Wren and Grace?
It's a straight out. You
Shall
take
issue?
the classes and it's straight out shall issue exactly.
Oh wow.
Yeah. I know people who got licenses. It's easy.
And are they able to carry, given all the other
Yeah.
regulations here?
Yeah. I mean, I don't know.
Being too close to a government building.
Right,
and this
yeah,
Other
I know,
things,
yeah.
Swiss cheese.
Yeah, I don't know.
You could go right up to 10, 15, even a minute or two longer if you need to. So
Okay.
because we have a break after this.
Okay.
It's all.
Good morning.
So the two big issues. Yeah.
Good morning and welcome to the Federalist Society's program on the Second Amendment in the Supreme Court. My name is Dean Reuter. I'm Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. Very pleased to see all of you here this morning. Thank you for braving the weather and coming out to our program. I want to also welcome those of you who are joining us on the live stream, and for the people in the live audience, when we get to the portion of the program where we have audience questions, there's a floor mic, so please use that so we're recording and you'll appear on the live stream as well. We begin this morning with a panel on does the right to bear arms include a right to carry handguns in public? I'm very pleased to welcome our moderator, the Honorable Gregory Katsas of the D.C. Circuit Court of Appeals. He's known to, I think, probably everybody in the room, so I'm going to leave it at that and turn things over to Judge Katsas.
Thank you, Dean. We have two great panels this morning on the scope of the Second Amendment. I'm sure everyone in the audience knows the Supreme Court in Heller held that the Second Amendment recognizes an individual right to possess firearms and to use them for traditional purposes, including self-defense in the home. Heller also said, though, that the right is not unlimited, and it recognized two kinds of restrictions which give rise to the subject matters of each of our panels. The first kind of restriction involves the places where the Second Amendment applies. The court held that it would be unconstitutional to ban firearms in the home, but it said pretty clearly that it would be constitutional to ban the possession of firearms in what it called especially sensitive places like schools and government offices. And that gives rise to the question before us, which is, well, what about everywhere else? And what about the right to bear arms in public? The second question, which the next panel will address, goes to the nature of the firearms, what types of firearms are or are not protected, and in particular, can the government ban semi-automatic rifles? We've got a wonderful panel right now. Our first speaker is Dr. Stephen Halbrook. He is a senior fellow at the Independence Institute. By my count, he's written at least 9 books on the subject of gun control and the right to bear arms, not only under the Second Amendment, but throughout the world. He's taught legal and political philosophy at 3 different universities. He's testified before 4 different congressional subcommittees, and he's argued and won 3 cases in the Supreme Court. The most significant of those was Prince versus United States, which is best known as a 10th Amendment commandeering case. But it's also the case in which, more than a decade before Heller, Justice Thomas suggested that, contrary to the popular view at the time, the Second Amendment might actually create an individual right to bear firearms, and for that proposition, he cited one of Dr. Halbrook's books. Our second panelist is Jonathan Taylor. He is a principal at the Gupta Wessler law firm, where he represents plaintiffs and public interest clients in the Supreme Court litigation, Court of Appeals litigation, and constitutional litigation. He's a cum laude graduate of Harvard Law School, and he began his career clerking for Judge Ronald Gilman of the Sixth Circuit. In 6 years of practice, he's managed to build up some expertise in a remarkable range of areas, including the First Amendment, the Second Amendment, the Fourth Amendment, Article III, class certification, civil rights law, administrative law, and consumer rights law. Most relevant to today, Jonathan was the prevailing counsel in a case called Gould versus Morgan, where the First Circuit upheld restrictions on public carrying as permitted by Massachusetts law and as implemented in Boston and Brookline. Stephen was on the other side of that case, and I'm sure it's one about which we will likely hear more. With that, Dr. Halbrook, the floor is yours.
Thank you, Judge Katsas. It's a real pleasure to be here. I'm told I have 15 minutes for an opening statement, and I don't know if we have a timekeeper, but I'll just, and when judges tell me that your time is up and the red light comes on, I know what to do. So I'm going to talk about the right to bear arms. And it seems like it would be a simple topic. The Second Amendment provides that the right of the people to keep and bear arms shall not be infringed. And the question is being hotly litigated in the minority of states that have so-called discretionary license issuance for carrying handguns. Whether bear arms means that you have some kind of constitutional right to carry a firearm outside your home. And the first thing is just the words of the Second Amendment would seem to be conclusive about that. A right to keep arms and a right to bear arms, those are distinguished. Keeping arms would obviously include keeping them at home. So bear has nothing to do if it means that you can carry arms in your home. It's got to be something more than that. And by the way, when the Bill of Rights restricts some element of the subject to the home, it says so very clearly. In the Third Amendment, for example, soldiers will not be quartered without the consent of a person in that person's home unless in times of war. So when there's a restriction of an activity to the home, the Bill of Rights plainly says so. The word houses appears in the Fourth Amendment, obviously, in terms of search and seizure issues. So really there's nothing for the word bear to do unless it means that you can carry a firearm. And when reference is made to the right of the people, one would think that that would include society at large, people, individuals at large, and not those that would be chosen by government to exercise a given right. You cannot imagine referring to the right of the people to assemble in the First Amendment, and the government gets to decide who has that right, and you have to get a license, and you only get it for a good cause or for some reason that's different than other people. So that's the text. And then we move on to District of Columbia versus Heller. It's true that that case, the complaint in that case alleged that there's a right to keep arms in the home and that therefore the DC handgun ban was unconstitutional. And of course the court so held, but there's a lot in that decision about the right to bear arms, the right to carry arms. And in fact, Justice Scalia's opinion goes into great detail in the course of refuting the idea that bearing arms only refers to bearing arms in the militia, about the fact that carrying arms is what bearing arms means. There's a good quote in that case from Justice Ginsburg from a decision under 18 U.S.C. 924C about what it means to carry or to bear arms, and she refers to the familiar language of the Second Amendment and states that that means carrying, for example, a gun in the pocket or otherwise on the person. And as you just heard, the Heller decision also refers to restrictions on the right, the Second Amendment right generally. One of those was that you cannot carry in sensitive places like schools and government buildings. That would seem to imply that, non-sensitive places are places where you can carry. So in addition to that, the decisions that the court relies on in Heller talk about the right to actually carry arms, handguns, for example, and the court refers to some of the 19th century cases, Nunn versus State from Georgia and then Andrews versus State in Tennessee. In those two states, there were times when the legislature declared a prohibition on carrying handguns either openly or concealed, and those laws were invalidated. And Heller, toward the end of the decision, states that, well, the DC law is somewhat like these laws in the 19th century. It's so extreme in terms of prohibiting the right to bear arms altogether, and in the same token, the District of Columbia was prohibiting the right to merely possess handguns altogether. One more part of Heller makes clear that under the basis of the court's decision, although the issue wasn't squarely before the court, that there's a right to carry outside the home, and the court refers to the fact that, well, the Second Amendment has a militia clause, but for the people who lived at the time of the founding, even more important to them was the right to carry arms for self-defense and for hunting. So these are all activities. You don't go hunting in your home. You don't. You may or may not have to defend yourself in the home, but certainly militia activities do not take place in the home. So there's a lot in Heller to go on here in terms of predicting what might happen in the future in the court. And we move on to McDonald versus the City of Chicago, which applied the Second Amendment to the states through the 14th Amendment. The very first carry law that the court refers to in terms of what the 14th Amendment was intended to invalidate was the Mississippi Black Code from 1865, which provided that no African American, no freed person, no freed slave could carry a firearm without some kind of permit from the authorities. And in fact, those types of statutes pervaded both the slave codes and then later the black codes from the early Reconstruction period, requiring a permit that's solely at the discretion of the issuing authority in terms of whether the person could have a right to bear arms. And so there were a lot of African Americans who were arrested and prosecuted and their guns seized and confiscated under these laws. And you'll see speeches in Congress about the purpose of the Second Amendment in terms of wanting to get rid of these laws and validate them. You also have the passage of the Freedmen's Bureau Act in 1866, which, under which 2/3 of the same Congress that passed the 14th Amendment and sent it to the states for ratification, 2/3 of the same Congress voted for the Freedmen's Bureau Act, which explicitly declared that the rights to personal security and personal liberty included the right to bear arms. And they were referring to the right of African Americans to have the rights of full citizenship, which included the right to carry arms outside the home. Now there's a third Supreme Court case that It was like Mark Twain said, the reports of my death have been greatly exaggerated. If you remember, after Heller and McDonald, the Supreme Court wasn't granting cert in any Second Amendment cases, and it was like, you know, maybe they're never going to take another one. And then all of a sudden, they took a case based solely on the petition, the cert petition and the opposition to it from the state of Massachusetts involving the stun gun ban in that case. There was a woman who had been threatened and beat up by her ex-boyfriend, and she had a stun gun, and she was busted in a parking lot with the stun gun, which was prohibited under Massachusetts law. And the Massachusetts Supreme Judicial Court upheld that law, and it went to the Supremes, and they said, hold on, like, your reasoning is totally out of whack with what we held in Heller. The weapon doesn't have to be a type that existed at the time of the founding, that because Heller had made clear, like, just like modern communications and exercise of free speech and free press, there was no internet at the time of the founding, but under the speech and press clauses, the internet is still protected, and by the same token, the types of weapons, if they're commonly possessed by law-abiding people for lawful purposes or typically possessed for lawful purposes, they're protected by the Second Amendment. And so the Supreme Court, simply on the basis of the petition and opposition, reversed and remanded the Massachusetts court and said that go back and look at this again under our precedents. You've not been consistent with what we've ruled. And the interesting part about that case, which there's more detail about it in Justice Alito's concurring opinion, is that it took place outside the home. So had the court thought that there was no right to carry any kind of arm outside the home as guaranteed by the Second Amendment, the court could have dealt with the case that way. There was no reason to go into the analysis of the type of weapon. So yes, the court didn't make that explicit proposition, but that was assumed in the case, and that was a 9-0 per curiam opinion, assuming that there's a right to carry outside the home. As the judge mentioned, the Gould case out of the First Circuit is one that my colleague John and I participated in different roles. He got to argue. I didn't get to do that. But what's funny about these cases, or interesting, is how the turn into like ancient history becomes a big part of the case. Specifically, you see a lot of briefs about the Statute of Northampton from the 1300s in England, and that was 50 years before Chaucer wrote the Canterbury Tales. How many of you remember reading that in high school, the Canterbury Tales? We were just high school kids. We thought it was really funny. I remember the phrase, somebody called somebody else a naughty knave and a saucy fellow, and we thought that was just hilarious. But here's a statute that the argument seems to be that it overrides the Second Amendment because it was something passed by a monarch in medieval England, and that's become a big part of the briefing. And it's really fun to do that kind of briefing, but like the D.C. Circuit said in the Wren case that overturned D.C.'s discretionary license issuance regime, that we're not turning the clock back to the time of Chaucer, and that's not what the Second Amendment talks about. It talks about the right to bear arms. Look at the text and the structure, and look at the different decisions. Look at the Heller and McDonald cases, and so we're not going to be bound by those old laws. What the Statute of Northampton did was to prohibit going armed, riding or going armed, and it also had language about doing so to the terror of the king's subjects. And the way the English courts ended up construing that was it was an offense to go armed only if you did so in a manner that terrified other people. So if you were carrying concealed, obviously you wouldn't be doing that. Or if you were simply peaceably going about your business, you wouldn't be doing that. And but anyway, in that debate, there's a case, Sir John Knight from 1686, and the court agreed with that construction of the Statute of Northampton, that it only precluded going armed to the terror of other people. Then you get to William Hawkins and Blackstone and all of these people, and so you'll have a lot of arguments. So it's really fun arguing these really old authorities, but they don't count as much when you look at the text of the amendment and the fact that we have Heller and McDonald giving a lot of guidance in terms of what the amendment protects. And we also have to look at the unique situation here in the U.S. What parts of the common law did the colonists carry over? The first declaration of rights to mention a right to bear arms was that of Pennsylvania, and it referred in 1776 to the right of the people to bear arms for defense of themselves and the state, clearly an individual right. You have different variations of that being adopted before the Second Amendment by other states. And then finally, you have the Second Amendment itself. And we used to debate whether the Second Amendment referred to a collective right of basically nobody to keep and bear arms, the National Guard or whoever it would be. And that argument became abandoned by the time of Heller, and you'll see even in Justice Stevens' dissent, he wants to talk about an individual right to bear arms in the militia, and that's the exclusive protection that the amendment provides. In any case, there's no question under these state guarantees that there's a right to bear arms outside the home, and in fact most states do provide for what are called shall issue license regimes, under which if you meet certain qualifications, like you pass your background check, have certain training, and otherwise, then you can get a permit to carry, and that you can carry for self-defense other than in certain places where carrying is banned. So that's the law in almost all states, but there's, I don't know, maybe 7 or 8 states that have the discretionary issuance. Anyway, what's the Supreme Court going to do? And that's fun to always speculate about, and we never really know what might happen with that. But, you know, in the Wren versus D.C. case, the D.C.'s law was overturned, and the D.C. Attorney General reviewed whether to petition the Supreme Court. And and this was in the newspapers, the attorneys general from other states where may issue license laws existed, and in circuits that have upheld these laws, first, second, third, and fourth, bore down on the D.C. Attorney General, like, don't go there. D.C., you made this mistake once before when you insisted on taking the handgun ban case to the Supreme Court. And that ruined everything to start with. I mean, that did away with the Second Amendment as only a collective militia right theory. And the Second Amendment does mean something, so don't do it again. And the D.C. Attorney General, therefore, did not petition the Supreme Court. And so we have 3 circuits, basically, in agreement with that. And that would be the D.C. Circuit, the 7th Circuit, and the, well, this is kind of weird, the 9th Circuit. The 9th Circuit has gone in different directions. First, there's a case called Peruta versus San Diego, where discretionary license issuance was upheld for concealed weapons. California, during that litigation, also banned open carry of handguns, but the court refused to deal with that issue. It started out the policy of discretionary issuance was invalidated by a panel decision 2-1, and then in Bonk, though, the 9th Circuit reversed and said that discretionary issuance on concealed weapons is okay, but we're going to close our eyes to whether you can carry firearms openly under the Second Amendment. And so you have some strong dissents to that. But then the same issue came up again. The state of Hawaii doesn't issue any kind of licenses. The only license you can get is an open carry license if you're a security guard. And a 2-judge panel with 1 dissent held in Young versus State of Hawaii that that can't be the meaning of the Second Amendment. It's not limited to security guards. And so that panel said that that policy was invalid. And of all things, that was a preliminary injunction case. It went up to the Ninth Circuit, and the Ninth Circuit affirmed at that level under the preliminary injunction standard that the case was sent back for further proceedings. So as of that decision, the Ninth Circuit is on the record saying that you can carry openly, and that's guaranteed by the Second Amendment, but not concealed under the en banc Peruta decision. So Judge Gorsuch on the 10th Circuit made some comments about Second Amendment issues, but more in terms of felon in possession issues, and you might have noticed the court's grant of cert in a case involving whether it's an element of the offense that the government has to prove a felon knew of that status as a prohibited person. There was a 10th Circuit case that Judge Gorsuch dissented in where the state court judge had said to the defendant that you're not a convicted felon because the case was going to be somehow nullified at the end of the probation period, something like that. And so the guy possesses a firearm and then he gets prosecuted for it despite that advice. And so anyway, that's not a carry case, obviously, but that's something that a case where an opinion was rendered that did involve Second Amendment issues. And then we've got Judge Kavanaugh, of course, who dissented in the Heller 2 case, about which you'll hear more later. He would have held not only that the D.C. ban on semi-automatic rifles was contrary to the Second Amendment, but also that the parts of the D.C. gun registration system was also not justified under the Second Amendment, and he used the methodology of text, history, and tradition as opposed to levels of scrutiny like strict scrutiny or intermediate scrutiny. So there you have an understanding of the Second Amendment that I think would be potentially favorable to hearing the issue of the right to carry if the Supreme Court does grant cert. So we've got some new kids on the block, if I can use that term, in the court, and so we'll see what the court does next. But that's what makes this subject so much fun, and I think John will have something to say about that too. Thank you very much.
Thank you.
Thank you very much. Thanks to the Federalist Society for inviting me. Thanks to Dr. Halbrook for being a worthy adversary on this issue. Thanks to Judge Katsas for moderating. It's a particular luxury to be able to get out uninterrupted 15 minutes of argument before being asked questions by a federal court of appeals judge, so I'll try to make use of that time. Before I do, though, before I jump in, I just want to lay out the roadmap for my remarks. And I want to begin with a discussion of Heller. I think it's where any discussion of the Second Amendment has to begin. And in particular, I want to focus on what the court said the Second Amendment protects, but also what the court said the Second Amendment doesn't protect, because both are important, and Judge Katsas mentioned both in his introduction. And then I'll turn to the lower courts, the courts of appeals, which in applying Heller, they've coalesced around a two-step framework where the first step is, does the law at issue burden conduct that is protected by the Second Amendment as historically understood? And if it does, then courts have proceeded to the second step, which is analyzing the law under some form of scrutiny, typically intermediate scrutiny. Now, there have been some notable dissenters from that approach, including most notably Judge Kavanaugh, but that's been the basic approach. And when the courts of appeals have analyzed public carry restrictions of the sort we're discussing today, in particular the good cause requirement, they've typically applied this approach, and the majority of courts have upheld these laws under intermediate scrutiny. That's a fine approach, but the defense that I want to make today for why I think these laws are constitutional is one that is fully consistent with Judge Kavanaugh's interpretation of Heller, and one that I think hopefully even some of the folks in this room might find appealing. It's rooted in history and tradition and federalism and respect for Heller. So let's begin with Heller, because I think, as I mentioned, that's where we have to begin. The court's opinion in Heller is it's 4 parts. And the first part we can ignore. It's just a discussion of the background in that case in the procedural section. But parts 2, 3, and 4 are critically important, and I'll just walk through each of them. Part 2 says what the Second Amendment right protects. And the principal disagreement that the court is resolving in Heller, of course, is whether the right protects an individual right to keep and bear arms or a collective right. And the court resolves that disagreement in favor of the individual rights approach, but in doing so, it looks to not only the text of the Second Amendment, but history and tradition, and for that reason has been regarded by many as a kind of high watermark of originalism. And the court's approach, in particular, in canvassing the history, the court looked to the English history, which Justice Scalia found highly relevant because the Second Amendment speaks of the right to keep and bear arms, which assumes a pre-existing right that was inherited from our predecessors in England. And then the court also looked to the early American tradition to inform the shape and the scope of the right. And the historical materials that it consulted weren't just limited to the founding era, but also extended all the way through the late 19th century, because all of that time period is important to the constitutional analysis. And the court, after consulting all those historical materials, came to the conclusion that the Second Amendment protects, quote, the right of law-abiding, responsible citizens to use arms in defense of hearth and home. So that's the core, self-defense in the home. Now, it's not necessarily the only right that is protected, but it is the core of the right. And so then the court proceeds to the next part of its opinion, which is equally important, which is what the Second Amendment doesn't protect. And the court said explicitly the Second Amendment right is not unlimited like other constitutional rights. And so how do we know, what those limitations are? The text of the Second Amendment doesn't tell us. It just says that the right of the people to keep and bear arms shall not be infringed. You're not going to find answers to difficult questions by staring hard at that text all day. And so instead, we have to look to history and tradition, the same things that led the court to conclude that the Second Amendment right is an individual right, also help guide the court in determining what the contours are. And so the court said explicitly, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation or to keep and carry any weapons whatsoever in any manner for any purpose. And instead, the court explained that long-standing prohibitions are seen as tradition-based exceptions to the Second Amendment and are thus constitutional by virtue of their historical justifications. And that's not my language, that's the language from Heller. And examples that the court gave of these lawful, long-standing regulations are long-standing prohibitions on the possession of firearms by felons and the mentally ill. And these are notable because these prohibitions, while long-standing in the court's eyes, have been around for only about 100 years or so. And so I think that what the court is saying is you don't just look to the time of the founding to see if a law is long-standing, but you consult the full tradition in this country. And so then the court, the last part of its opinion is the application of the Second Amendment as the court has interpreted it to the law at issue in the case. The law there was a total prohibition on owning any handguns anywhere. And the court said that this amounts to a destruction of the right. And it notably did not apply any of the levels of scrutiny that the court has typically applied when assessing a challenge based on an enumerated constitutional right. But it said that it would fail under any of them. And it didn't apply rational basis, and it didn't apply Justice Breyer's freestanding balancing test. Now, the lower courts in interpreting Heller, as I mentioned at the outset, they've coalesced around this two-step approach, where you start with consulting the history and asking whether the law is long-standing, and if it is, the analysis ends there. And if it's not, then you proceed to apply some form of scrutiny. Typically, courts have applied intermediate scrutiny, but there are some notable dissenters on that front as well. Justice Kavanaugh in Heller too, which Dr. Halbrook argued, he dissented from this approach. In his view, Heller mandates a historical, tradition-based test only. You don't, if a law is longstanding, it's constitutional. If it's not, it's not. That's the end of the analysis. Now, most of the courts of appeals that have addressed good cause restrictions, they have assessed the law by assuming that it burdens conduct that is protected by the Second Amendment, and then skipping ahead to step 2, applying intermediate scrutiny because the law doesn't infringe on the core of the right, which is armed self-defense in the home, and then upheld the law under intermediate scrutiny. That's a fine approach, but I want to instead make the argument, which I think Justice Kavanaugh might find appealing, and which some of the folks here might find appealing, which is that these good cause laws are longstanding and should be upheld at step 1 because they are consistent with our historical tradition. And this is an argument that my firm and I have made on behalf of Everytown for gun safety. After Everytown uncovered a number of old historical laws, and we brought them to court's attention in the last few years, and then I've made the argument in the Gould case, which we discussed at the outset. Now, in framing the historical question, the inquiry whether these laws are longstanding, you first have to have a handle on how these laws operate on the ground. And so I'm speaking about good cause laws, and my friend has characterized the question as whether a total prohibition on carrying firearms outside the home is constitutional, but that's actually not what these laws do in practice. So if you look at the Gould case, which I argued, the plaintiff in that case, he had requested an unrestricted license to carry a firearm in public from the town of Brookline. And he was denied that license, but he was given the ability to carry a firearm in his home, at work, while traveling to and from work, even late at night, while hiking, which was a purpose he articulated as being particularly important to him, and while target shooting and under a number of other circumstances. Now, in circumstances beyond those, he was restricted from carrying a firearm. But I think the question then whether the Second Amendment has any purchase outside the home is a fine one, but it's not ultimately going to answer the question whether a regime like that is constitutional. And I think instead you ask whether the restrictions that are imposed find sufficient support in our history and tradition to be deemed long-standing and constitutional under Heller. And I think that for a few reasons, these laws are long-standing. The first is you look to the English tradition that my friend mentioned, which dates back all the way to 1328 in the Statute of Northampton. And that statute, which admits of no menacing behavior requirement on its text, was in effect for hundreds of years, up to and past the English Declaration of Rights, which recognized the right to keep and bear arms, which is the predecessor right to our Second Amendment, as the court said in Heller. And that law was a broad prohibition on carrying firearms in fairs, marketplaces, and any place where people congregated in public. And courts, there's a decision from the King's Bench in the 17th century that interpreted that law to have no exception for people who just peacefully carried a firearm. The very act of carrying a firearm was considered to be in terror of the people and therefore prohibited by that statute. That tradition then took root in early colonial America, where a lot of the colonies and states passed mirror images of that statute. And then a few decades later in the early 19th century, beginning with Massachusetts in 1836, some states started to take a more permissive approach to public carry and allowed some form of public carry if someone had a good cause for doing so. And so these are kind of the early predecessors to the regimes that you see in a number of states today that cover a quarter of the American people. And then after, immediately before the Civil War and after the Civil War, which is a highly relevant time period when you're talking about the scope of the right to keep and bear arms as applied to the states through the 14th Amendment, these states, and there are over a dozen states and over a dozen municipalities, on any understanding of the laws that they enacted, these laws were at least as restrictive as the good cause laws that you see today. They either prohibited, broadly prohibited public carry in populated urban places, or they required a good cause for doing that. And so however you want to read the English history, however you want to read the early good cause laws, you cannot deny that these laws, which are older than the laws recognized by the Supreme Court in Heller as longstanding, broadly prohibited public carry and therefore form sufficient basis for upholding good cause laws today. Now, that's not to say that this was the only approach taken by states in this country. There was another approach, primarily taken in the South, that was a lot more permissive of public carry. In this sense, it just mirrors the policy debate you see today, where one half of the country takes a certain view of firearm ownership and the other half takes a different view. And that is what you would expect in a federalist system. And the question now is whether you end that long-standing debate, that policy debate, and constitutionalize it and declare one side right for all time. And the way that they interpreted, gun policy now must govern every state in America. And I would submit to you that that's not the right approach. It's not the approach that Heller requires, and that the better approach is to recognize that both traditions in this country are fully consistent with the Second Amendment and constitutional. Thank you.
We are right on schedule, so why don't I give each of our panelists about 5 minutes for rebuttal. Stephen.
Thank you. First, I want to start with the standard of review. In Heller, what did the court do? It looked at the text. It looked at history and tradition. It didn't use that phrase exactly like that, but that's what Judge Kavanaugh, how he described it in Heller too. But that's what the court did. It looked at the English tradition, saying that the right was fundamental for the original settlers who took the English traditions. And it used the word fundamental right twice, by the way. And when we litigated Heller 2 in the district court, the opinion denying all of our claims said, well, the court didn't say the word fundamental right enough. It only said it twice. So we're not going to treat this as a fundamental right, because we were arguing strict scrutiny at the time. And then McDonald came down, and I think it uses the word fundamental right like about a dozen times. But anyway, Justice Breyer's dissenting opinion in Heller, of course, was that it was akin to intermediate scrutiny. He relied on the same cases. And that was, of course, soundly rejected in the majority opinion. But that's where the lower courts have gone. They've gone to intermediate scrutiny, and it's basically becoming a balancing test where you look at, you use this two-part test, and you end up with, we can ban carrying outside the home, we can ban semi-automatic rifles, whatever, because the government says that that's necessary to prevent crime. If you look at Heller, though, the Breyer dissent would rely on committee reports and statistics and criminological data, and the majority said, no, we don't go there. That's what's off the table is what's guaranteed in the Second Amendment. So that's where I think the Supreme Court needs to step in and clarify the standard of review. Looking at the history, the tradition in the United States in the 19th century, actually the southern states by and large enacted concealed weapon laws, which implied that there was no going armed prohibition, because otherwise why would you need to ban concealed weapons if it was already illegal? But the northern states did not. The Massachusetts law from 1836 provided that, did not provide that it was a crime to go armed. It said that if you go armed, and you don't have, if you're not feeling threatened, a person can bring a petition, and if that person reasonably can show that that person is threatened by you or that you're threatening a breach of the peace, that person can basically get a peace bond where you have to get sureties to guarantee your good behavior. And so that was not a ban at all. That was like you've got to actually threaten people, And everybody could agree with that. That's fully consistent with a constitutional right to bear arms, that if you do that and then you threaten other people, or that you're likely to commit a breach of the peace, we don't want people like that going around being armed and engaging in that kind of disruptive behavior. So there were basically no carry restrictions in the northern states as long as it was peaceable. And in fact, New Jersey, which today has some of the most stringent restrictions on carry, open carry was legal in that state until 1966, which sounds incredible. And open carry, by the way, is still lawful, and it never has been restricted since colonial times in most states. The Commonwealth of Virginia is a good example. Delaware, you can go down the list. So there is no long-standing tradition of saying that we're going to delegate to the authorities a decision about whether you need to carry a gun as long as you're doing so peaceably. The good cause restrictions basically delegate an arbitrary power to law enforcement authorities to decide whether you've given good enough reasons. That's kind of weird for a constitutional right to be in a status like that. Now, it's true in the Gould case, Mr. Gould had a limited license where he could carry at different places, but he couldn't generally carry in non-sensitive places for self-defense, and that's really what the issue is here. In many jurisdictions where you've got discretionary issuance, you don't get any kind of carry license, even to carry in the course of business or to carry it at certain places like hiking in the case of the Gould case. So, you know, there's different ways these laws are enforced. You'll get some law enforcement authorities that give out a license fairly readily, and others who don't. California is a good example. I think San Diego changed their policy in the Peruta case, and the sheriff I think it was a new sheriff, and they changed the policy to a more permissive issuance. But the bottom line is, and this is what the Supreme Court needs to decide on, because there is a circuit conflict to decide on whether there's a constitutional right to carry per se, and then after that, obviously, then the scope of the regulations become an issue, whether they're consistent with Second Amendment rights. So, thank you.
Jonathan, thank you. Yeah, just a couple of quick points in response. Just on the standard of I guess the better way of articulating is the methodological question of how you assess a challenge, a constitutional challenge to a gun law. Heller, it is true that Heller eschewed at least express application of some level of scrutiny, but Justice Scalia, in his opinion, says he's referring to Justice Breyer's dissent. Justice Breyer proposes explicitly, at least, none of the traditionally expressed levels: strict scrutiny, intermediate scrutiny, rational basis, but rather a judge-empowering interest-balancing inquiry that asks whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests. So I don't read that language to be rejecting the application of some level of scrutiny, but if anything, quite the opposite, and that's the way that the lower courts uniformly have read that language, with the exception of some dissenters like Justice Kavanaugh, who has taken a tradition and history-based approach only, an approach that I think actually squares very nicely with the defense that I just laid out. Now, just briefly on the 19th century and early 20th century laws, my friend looks to these good cause early laws, beginning with Massachusetts in the 1830s and then carrying through to the end of the 19th century. And that's fine. I mean, I could quibble with the way that he's characterized it, but I think the broader point, which he cannot deny, is that a number of states, both before ratification of the 14th Amendment and after, clearly prohibited the carrying of a firearm without good cause or beyond. So I'll give you a couple of examples so you know that I'm not just making this up. West Virginia passed a law that made clear that, quote, if any person go armed with a deadly or dangerous weapon without reasonable cause to fear violence to his person, family, or property, he may be required to face criminal penalties. Courts construed the self-defense exception quite narrowly to require specific evidence of a concrete, serious threat. In the early 20th century, over 100 years ago, Massachusetts passed a law prohibiting public carry unless you could demonstrate a good reason. So that is effectively unchanged from its law today. And then I would also say, look at some of the state court cases. So the Texas Supreme Court, for instance, twice upheld that state's good cause requirement. Once in 1871, 3 years after the 14th Amendment was ratified, and then again in 1874. And the court explained that the law thus made, quote, all necessary exceptions, and noted that it would be little short of ridiculous, their words, not mine, for a citizen to claim the right to carry a pistol in places where ladies and gentlemen are congregated together. Further, the court observed the good cause requirement was not peculiar to our own state, for nearly every one of the states of this union had a similar law upon their statute books, and many had laws that were more rigorous than the act under consideration. And the only point, the modest point I'm making now, is that these, nearly a dozen states that have continued this tradition today are not violating our Constitution by doing so.
Okay, we have plenty of time for questions. If folks want to ask them from the microphone, I'm just going to begin by exercising moderators or judges' prerogative and start the questioning, but please feel free to line up. So first for Stephen, it seemed as though in your presentation you were running away a little bit from old history, and you said something like, well, we're not going to be bound by old law. That might be persuasive if you're dealing with, say, an Earl Warren opinion on evolving standards of decency or whatever, but this is an Antonin Scalia opinion, and the scope of the right seems very much defined by the court's assessment of very old laws. So what is the basis for saying, well, we're going to look to old history to define what the right protects, but we're not going to look to old history necessarily to define the limits?
Right, thank you. And I didn't mean to imply that we don't look to the old history on the limits, but old history goes in different directions. Like when the Statute of Northampton came before the King's Bench, 1686, the King's Bench ruled that the carrying, that Sir John Knight's carrying of weapons was not in violation unless it was done to the terror of the subjects. And the jury found him not guilty. That was an element of the offense, that it had to be to terrorize other people. The gun had to be carried in a manner that did that. Now, the prosecution probably didn't look at it that way. And the prosecution, by the way, was, society was deeply divided between the monarchy, and this was 2 years before the Glorious Revolution when William and Mary ascended the throne. So yeah, the Statute of Northampton did have different ways it could be interpreted. The prosecution in Knight versus Sir John Knight's case tried to get a conviction where under the facts, whether there were threats or not, I mean, that was a jury issue. But what I'm getting at is we do look at these old cases, for example, and old traditions in terms of the historical development, but how did they come out? And in that case, and then in the antebellum cases where it was considered a common law offense, for example, in North Carolina, to go armed to the terror of the fellow citizens, there were decisions by courts saying that that only is the case when you carry arms in a manner that threatens other people. And in fact, there was one one of the indictments had to do with a guy who went to a widow's house and was firing his gun, and those are all things that alarm and terrify people. So that would state an offense. So now there are some state laws and decisions that are outliers in this process. Texas is a good example. John mentioned basically it was a prohibition on carrying a handgun unless you're traveling. And that law persisted until about the 1970s. And so if people were stopped with a handgun in Texas, they would just say, I'm traveling. But it did not ban carrying long guns. So, and as I say, it was an outlier. There were no other states that had that stringent of a law. One of the cases, Reconstruction cases that the Supreme Court cites in Heller is Andrews versus State. That was a Tennessee case that invalidated a basic carriage law that applied to handguns generally. So I'm not trying to run from history. I think what I'm trying to do is to show that the history, the way it developed, and you do have minority views in history, but just like Heller did, there were some old cases it discounted and others that it agreed with.
Thank you. Jonathan, you embraced history in your presentation, but let's talk for a second about the broader legal framework and what the lower courts have been doing. And you made brief reference to this, but it seems like the courts are putting a lot of weight on this distinction between core and periphery. And you said, okay, the core is use of a handgun in the home for self-defense. Right? Why is that sort of a legally separate category as opposed to simply the facts of Heller, right? I mean, if you imagine a different case involving restrictions on rifles outside the home used for hunting, presumably, I would bet Justice Scalia would say all of the same things, even though it's neither a handgun nor the home.
Well, I guess a couple of responses. So you're right, I think it's true that it was the facts of the case, but the court did say explicitly that whatever else the Second Amendment leaves to policymakers, it surely elevates above all else the right of law-abiding, responsible citizens to carry and use firearms, or use firearms is what the court said, in defense of hearth and home. And so I think that what the court is saying is that armed self-defense in the home, and this is consistent with the Castle Doctrine, if you're going to look to self-defense principles, are at their zenith in the home. And now I think the way that lower courts have construed the Heller opinion is they said, let's assume, because this can be a thorny question that potentially requires courts to resolve historical disputes, and as for the reasons I've articulated, I think that you can say that both strains of history are constitutional here, both strains of our tradition, that is. But courts have been, some courts have been reluctant to wade into the historical materials, and they've instead assumed that the right is burdened in some way by these laws, skip forward to scrutiny, which they're a little more, courts tend to be a little more comfortable doing, and they, given the option of applying either strict scrutiny or intermediate scrutiny, some courts, most courts in fact, have effectively adopted an approach that said if you're dealing with armed self-defense in the home, then you might apply something more closely resembling strict scrutiny, although I don't think, to my knowledge, any court that wasn't subsequently reversed en banc has actually applied strict scrutiny. But when you're dealing with more modest restrictions, something short of a total ban on handgun prohibition everywhere, like the one at issue in Heller, then we are going to apply intermediate scrutiny, and that makes some intuitive sense because the public safety justifications are not particularly strong, or not as strong, I should say, when you're dealing with regulating firearms inside the home as they are, as much as they are when you're talking about carrying firearms in public where people live. And I would also note that it's a little bit strange if you recognize that the court said that the carrying of firearms in sensitive places can be prohibited as a long-standing prohibition, to think that the Second Amendment is just, it's a binary choice, it's an on-off switch. It's either unfettered carry if you're not in sensitive places, or a total prohibition is permissible. I think it makes sense to say the right is strongest inside the home. There's a more a limited, a more sharply circumscribed right that might exist outside the home, and then that right is overcome by the historical prohibitions when you're dealing with sensitive places. And so that's the basic approach that I think is also consistent with our history and tradition.
Can't see too well looking into the lights, but I can make out some folks at the mic, so let's go to questions, please.
Okay. I want to understand, number one, first question, I want to understand clearly, the Supreme Court upheld the discretionary carry situation in California, but, you know, or actually refused to hear the, you know, appeal of the upholding of the discretionary carry in California regarding handguns, but at the same time overturned the Massachusetts ban on carrying the stun gun in public. Is that correct? So one case it upheld the, you know, ban on, you know, California ban on handguns, carrying handguns in public, but overturned the Massachusetts ban on carrying stun gun in public. Is that correct?
What it actually did was to say, we're going to deny the cert petition in the Peruta case out of the Ninth Circuit, and denial of a cert petition is not to be taken to mean anything on the merits. There's a strong dissent by Justice Thomas, joined by Justice Scalia a little bit before his death, which urged the court that they should be taking these cases, and this is not a second-class right. Now, in the Catano case, the court did not invalidate the stun gun ban, but the court remanded the case for further proceedings. Justice Alito would have invalidated it because we're talking about a woman who had been repeatedly attacked by this ex-boyfriend, and she remained under indictment even after the case was remanded. So, so we don't have a whole lot to go there. We have a cert denial with a strong dissent, and then we have apparently a premise in the Catano, Massachusetts case that that the right does apply outside the home, but not a clear statement of that.
I think that's a correct response, but if I could just add one important point of clarification on Caetano. So you're right that the court granted cert there and reversed the Massachusetts High Court's decision affirming the conviction. But the court took great pains to not break any new ground beyond what Heller itself had already held. And the court just said, look, the three reasons that were given by the Massachusetts High Court for why this conviction here doesn't tread on Second Amendment rights, all were rejected expressly by the full court in Heller. And so for that reason, the court vacated and remanded. But the court didn't have any occasion to consider the scope of the Second Amendment or whether it had any application or what the application might be beyond the home. And I think there, I could be remembering wrong, but I think that the person there might have been homeless or living out of their car. And so it was a messy, factual circumstance for presenting the question anyway. And I think she might have been arrested in or near her car.
And number two is, do you know with Donald Trump's new picks for the court when they get on there, do you know if there are going to be future plans to challenge discretionary carry restrictions in the courts?
Yeah, I'll take this one. There have been challenges that have been renewed in light of the court's changing composition. So the Second, Third, and Fourth Circuits have upheld good cause requirements as constitutional. They did so a number of years ago. A fresh wave of challenges were brought in the last year in these circuits, and they were filed solely for the purpose of being able to go to the Supreme Court and ask the court to take up the issue. And it's not just the court, the changing composition of the court that has motivated this strategy. It's also the fact that there is now, I'll say arguably, because I represent respondents in one of these cases where we'll be opposing a cert petition, but arguably a circuit split on this question. And so the cert worthiness of this issue is different potentially than it was when the court denied cert several times before. And in fact, there has already been one cert petition. It's pending out of New Jersey. It was filed by the law firm of Cooper and Kirk, which also represents the plaintiffs in the First Circuit case Gould that I mentioned earlier, and that is pending right now. And so it seems quite possible that the court might at some point take up the issue. And at that point, Justice Kavanaugh's opinions cannot just be dismissed as a dissent in the DC Circuit, but will have to be taken quite seriously as potentially the center of gravity of the court.
Is Gould still open on cert?
Yes, so the
timing?
plaintiffs there have sought and been granted an extension request, and their petition is due in a couple of months.
Okay.
And so if he's lucky, they'll take the Gould case.
He's hoping really hard they'll deny cert.
We're hoping for, we like to preserve the victories that we get in the lower courts.
Hi.
Yes.
Amy Sawyer from the Heritage Foundation. This question is directed mostly at John, but I would like to hear Stephen's thoughts on it as well. So you mentioned a number of states in the 19th century who developed and enforced certain laws regarding carry and good cause. It's my understanding that many of these laws were developed, enacted, or at least it began to be heavily enforced, largely as an end run around the 14th Amendment and the Freedmen Bureau Act as a means of discretionarily infringing on the rights of the freedmen and effectively disarming them while still allowing the militia members who had come back to retain their weapons. What are your thoughts on that and the accuracy of that analysis? And if that is a fairly accurate analysis, does it change how we look at those laws as longstanding if they were just an end run around the 14th and Second Amendments?
It's a good question. I guess the first point I would make just as a predicate to the response is that we're not only looking to late 19th century laws. We have a much more robust tradition dating back to medieval England and extending beyond that in the early 20th century, laws that wouldn't be tainted by any racially motivated purpose. The other point I would make, even as to this time period, is that there were a number of territories and states out west that clearly prohibited carrying firearms in populated areas that had nothing to do with some of the racial problems that we've had as a country. And that the same is true of the early 20th century laws. Now, as to whether these particular laws, some of them might have been motivated as by a desire to have an end run, as you put it, my understanding, I don't know as much about that particular question, and maybe Dr. Halbrook could enlighten me. But you don't see that based on the text or of these laws. You don't see, any racially motivated purpose, and I'm not aware of any in terms of how these laws operate on the ground or were enforced.
Yeah, if I could comment. Use Texas for an example. After the Civil War, laws were passed against the freedmen, and they were neutral on their face, unlike some southern state laws where they specifically mentioned freedmen and African Americans. It was neutral on its face, but it was aimed at the freed people. So first you have, I'm going to call it a carpetbagger government, and they could enforce these gun laws arbitrarily in favor of their friends and against the ex-Confederates. And when the ex-Confederates came back to power, they did the same thing. And you have the racial motivation. And so as long as it was, we can arrest whoever we want and leave other people alone, that's the way these laws get enforced. And there's a number of states passed on their face racially neutral laws, but then you have laws that were clearly aimed at poor people, African Americans, registration laws, and the laws that related to getting permits that wouldn't be given to certain kinds of people. And if we want to take the clock up, turn the clock up to the Gould case, who gets the licenses? And a lot of this has to do with, there were two defendants, Brookline and Boston chiefs of police. I know at least with the Boston permit policy, lawyers, doctors, and ex-cops get permits and other people don't. So you always have this potential for giving permits to our friends and not giving them to people who aren't. And there's been a bunch of people in the New York City Police Department, the license issuance people, were recently arrested because they were taking payoffs to give out licenses to people who paid them money. So that potential is always there, and I think when you get down to the policy level, if you look at the states where it's shall issue as long as you're a law-abiding person and you go through the procedure, those people don't abuse that right. You know, you can have the skies falling, horror stories predicting what might happen, but it never happens when these laws actually get enacted.
Yes, sir.
I would just, just 30 seconds. I think that if you were dealing with a statute that used the discretion that was conferred on local law enforcement by the statute to discriminate against particular groups, the challenge, the constitutional challenge you might be able to mount is one rooted in the discrimination and that targets that an equal protection challenge.
Yes, sir.
I'm Ahmaduddin Ahmed with the Minaret of Freedom Institute, and while I myself feel that strict scrutiny should be required in any infringement of right to keep and bear arms, I would like to understand better those judges who are satisfied to only apply historical and traditional considerations. A question to Mr. Taylor, and then I'd be interested in Mr. Halbrook's comment on the response, is if we set aside those laws that were motivated by racial considerations, it seems to me that the restrictions, that the justification for those laws relies on something like the prior restraint question in analogy with the First Amendment. That is to say, as starting with the Statute of Northampton and on to the others, that it's saying that if you're doing some kind of harm or threatening some kind of harm, then action can be taken against you. But that would be distinct from saying that in general, everybody needs a permit in order to do this, in analogy with not shouting fire in a crowded theater.
Right. Yeah, no, I think that, both parts of your question, I think, draw analogies to the First Amendment, right? We would apply strict scrutiny to a First Amendment challenge. We wouldn't do a tradition-based only analysis, and we wouldn't allow prior restraints. And so if you were to interpret the Second Amendment in precisely the same way that courts have interpreted the First Amendment, you might be right. But I think that, I could hardly improve upon what now Justice Kavanaugh said when he was on your court, Judge. And I think this is also a response to the beginning of your question, where he said, he's really the most prominent defender of a tradition-based only test. And he says, I'm going to maybe block quote if you'll indulge me for 30 seconds. It might be objected that the Supreme Court could not have intended a test cabined by text, history, and tradition, and analogs thereto when addressing modern weapons or conditions, given the prevalence of strict and intermediate scrutiny tests in the court's jurisprudence regarding some other constitutional rights. I disagree with that suggestion, and I think it is based on too narrow a view of the court's overall constitutional jurisprudence. Taking a step back, we know the Supreme Court has developed an array of rules, tests, and standards specific to each right. Particularly for a lower court, he's now, his job is to apply Heller as he sees it. It is difficult, therefore, to apply an overarching interpretive approach to questions of constitutional law that are necessarily guided by decades of precedent interpreting different provisions of the Constitution under different methodologies. And so I think it would be a mistake to read Heller and to look, as just mandating wholesale application of First Amendment principles.
If I could add to that, in the oral argument in the Heller case, Chief Justice Roberts, excuse me, asked Walter Dellinger arguing for D.C. Yeah. Like, didn't we make this stuff up about these rules of interpretation and strict intermediate scrutiny and all that? And it was sort of like, why don't we just ask whether the right's been being infringed, because that's what the language of the amendment is. And then turning to then Judge Kavanaugh, when we litigated that case, the Supreme Court had said the second's like the First Amendment, so we, from the very start, argued strict scrutiny, fundamental rights, strict scrutiny, compelling state interest, all that stuff. And when he came out with the dissent and said, well, the plaintiffs urge strict scrutiny because they think they'll get a better deal than they would under text, history, and tradition. We really didn't do that with that thought. We did it with the thought that this is the way the courts are doing analogous rights like First Amendment, and therefore we argued for strict scrutiny. But I mean, we're fine with text, history, and tradition, And by the way, also, Judge Kavanaugh said, even if we do apply strict scrutiny, and even if we apply intermediate scrutiny, the D.C. laws that are at issue in this case would fall. So,
when you say this case, you mean the case he considered, not the public carry case?
Right, yeah, this had nothing to do with public carry. This had to do with the registration system, which he would have invalidated because that's not a long-standing regulation.
Exactly.
And with the ban on certain kinds of rifles, so.
Right.
I think we have time for one more question.
Well, building off the last question, if the Supreme Court does take up a public carry case to resolve the circuit split, which level, if it picks a level of scrutiny, traditional level of scrutiny, which one do you think it would pick, and why would it pick that, or why do you think it should pick a certain one?
I think it's going to be text, history, and tradition, and the reason being that that's what the court did in Heller and McDonald. You know, you get past the text and you go into the English tradition, the colonial and founding traditions, and a lot of 14th Amendment history there, even though in Heller the Second Amendment was the issue, but the 14th Amendment was relevant because it showed what the country was thinking about the Second Amendment during that period, which was less than 100 years after the founding. So I think there's a good chance of that methodology being adopted, and Justice Thomas said in one of his dissents from denial of rehearing that here's different methodologies. That he cited the text, history, and tradition alternative, and he cited the levels of scrutiny, and he said we really ought to resolve that, and he said I'm not making a comment on where I would go with that, but that's something the court needs to do. So we're talking both about the substantive issues and the methodology of how we interpret these rights.
Yeah, I'll just make a few comments in response. I think if the court, in an ideal world for at least some members of the court, they would probably prefer to be faced with a total prohibition on carrying firearms outside the home, so they could issue a more modest opinion that tracks what the court did in Heller and says there is some right that exists outside the home, and whatever the shape and contours of that right are, that right cannot be totally nullified, and it would fail any of the traditional levels of scrutiny that we've applied in the past. But I don't think the court will have that opportunity, and so if it takes up one of these public carry cases where there is some modest ability for many people to carry firearms outside the home, it will be forced to, at the beginning, conduct a historical analysis and assess whether the law is sufficiently rooted in tradition and history to be constitutional. And if it concludes that the answer is yes, I think it would uphold the law. And if the court instead concluded that the answer is no, it has a few options before it. It could end the analysis there and declare the law unconstitutional, which is, I think, what Justice Kavanaugh has said he would do. Or it could proceed to what other courts have, really called the level of scrutiny. And it could either apply some form of scrutiny, either strict or not, or it could engage in some other form of analysis, and we just don't quite know. It could be that the court just does what it did in Heller, and it says, given the lack of a long-standing tradition, even if we were to proceed to apply some level of scrutiny, this law would fail it.
Could I have 15 seconds, Your Honor?
Sure.
The court just relisted New York State Rifle and Pistol Association versus City of New York. New York City will not let you take your handgun out of your home other than to go to a shooting range in New York City. You cannot take it to your second home in Vermont. You cannot take it to do a match in upstate New York. And that case is pending, and that's a pretty easy issue. You're not carrying it on the person. It's not loaded. None of those issues come up. It's like, is it held hostage in the home? They might as well put an ankle bracelet on it, and the court just relisted it. So maybe they'll take that. That'd be a very modest case to take.
Please join me in thanking our panelists for their really excellent presentations.
Greg, thank you so much. Thank you. That was really interesting.
I guess, Dean, we have a break for, break for how long, 15? We're in recess until 10:30.
Yeah.
Why don't we resume if we could, please? Welcome back to our second panel as we discuss assault weapons and their level of protection by the Second Amendment to the Constitution of the United States. I am still Dean Reuter, Vice President, General Counsel, and Director of Practice Groups. I'm moderating this second panel. We're going to hear opening remarks from each of our speakers of about 15 minutes. Mark Smith is going to go first, so we might give him some extra time because he'll be dealing with some definitions, then maybe some rebuttal, but as always, we'll be looking to the audience for questions, so please have those in mind for when we get to that portion of the program. Mark Smith is an attorney in private practice in New York City, the founding partner of his firm. He's also a presidential scholar at the King's College in New York City, a New York Times best-selling author, and the vice president of the New York City Federalist Society chapter. Mr. Smith served as a media surrogate for the Donald Trump for President campaign and served in the Trump presidential transition team as well. Among other books, he's authored several books. One of them is at your table today, #Duped. He's going to go first, and we'll hear from him for about 15 or 20 minutes. He'll be followed by Jonathan E. Lowy, who is the Vice President of the Legal Action Project at the Brady Center to Prevent Gun Violence. Now, since 1997, Mr. Lowy has argued in courts across the country to reduce gun violence, providing pro bono legal representation to victims of gun violence in lawsuits to reform gun industry practices, and assisting governments and public officials in defense of reasonable gun laws. He's litigated cases in over 30 states, successfully arguing several precedent-setting cases. He's published numerous articles on gun litigation and policy. We're pleased to welcome both of you here today. With that, Mark Smith.
Good morning. Thank you for having me here at the National Press Club and to the Federalist Society. Always a pleasure to speak both here and to the Federalist Society. I'm especially excited to talk today about our question presented, which is really whether ordinary semi-automatic rifles that happen to have a handful of incidental cosmetic features attached to them all of a sudden becomes unprotected by the Second Amendment and the Bill of Rights, even where these ordinary firearms are labeled assault weapons. Spoiler alert, the answer is yes. Ordinary semi-automatic rifles, just like ordinary semi-automatic handguns, are protected by the Second Amendment, and the U.S. Supreme Court's precedents demonstrate the same. Now, just so we're all on the same page about what an assault weapon is, and I'll get into a little bit more detail about this in a few minutes, but just to start off this presentation with that. Essentially, the gun controllers in America define assault weapons not as what they really are, which are fully automatic rifles used by the military to fight the Taliban in Afghanistan and the like. What the assault weapons are in the United States, in the context of the gun control debate, are ordinary semi-automatic rifles, which means you pull the trigger once, it fires one bullet and reloads, and that's it. These are ordinary semi-automatic rifles that are painted, ready, black, not the brown woodstock you see in hunting. They're painted black. They look like the military version of the M16, but they're not. They may look like that because of certain features that are defined in the various statutes that elevate or de-elevate in some ways an ordinary rifle into an assault weapon. And some of these features are things like muzzle brakes, pistol grips, stocks, and adjustable stocks that essentially adjust the firearm to your shoulder and to your height. But because of these characteristics that are really just cosmetic in nature, they turn ordinary guns into something that people try to ban and have successfully banned in 6 states, plus the District of Columbia so far. Now, semi-automatic rifles have been part of the American landscape for over 100 years. Semi-automatic rifles first went into the marketplace around 1903 to 1906. The scariest, if you will, from the gun lobby point of view, semi-automatic rifle is the AR-15 platform, which is what they always like to show because it's scary looking for many people, although not for gun owners and for people that are familiar with firearms. The AR-15 platform was designed in the 1950s and was definitely in the marketplace in the 1960s. As to when it officially went in the marketplace, there's a little bit of a debate between the 50s and the 60s, but by the 60s, it was definitely in the marketplace so that civilians could buy it. So we've had the AR-15 platform with us for over 50 years. Now, unfortunately, for those millions of Americans who are also, I should remind all, protected by the same Bill of Rights as the rest of us, millions of Americans in 6 states plus the District of Columbia are barred, prohibited from owning these ordinary firearms. And if they are caught with one, they face years in jail and become felons for simply an object in the back of their closet that is perfectly legal in 44 states in this country. And unfortunately, the federal courts are largely failing to do anything about this travesty. Every single court of appeals that has addressed a so-called assault weapon case has ultimately decided against the citizen and ultimately decided in favor of the state, of the government, over the Bill of Rights and over the individual. These challenges have been addressed and rejected by the Second Circuit in New York, by the DC Circuit, by the Seventh Circuit in Chicago, and by the Fourth Circuit, which oversees, among other states, Maryland. So why are we talking about the U.S. Supreme Court and the protections of the individual to own ordinary firearms with cosmetic features that some call assault weapons? Well, it's because of a change in the U.S. Supreme Court this year, or in the last several months. It's because of Brett Kavanaugh's elevation from Judge Brett Kavanaugh to Supreme Court Justice Brett Kavanaugh. You see, Brett Kavanaugh was the author of an approximately 55-page dissent that addressed the history, the text, and traditions and the technology of the semi-automatic firearms that were declared assault weapons by the District of Columbia's legislature. And in that dissent in the case known as Heller 2, he concluded that these weapons were undeniably protected by the Second Amendment. And it is significant because the Heller 2 case, in favor of banning these weapons and against the individual right to bear arms, this case has become what I like to call a super legal precedent. A super legal precedent, which all these other courts in the United States that have upheld bans on the individual right to own ordinary semi-automatic firearms with certain features. Heller 2 is really the foundational case that all these other courts have been relying upon to say, sure, we can ban them, and yet the dissent was by now Justice Brett Kavanaugh. So will the Supreme Court now address this soon? I suspect they will, and they should. After all, the individual right to self-defense is not only a fundamental human right that all of us have, Democrats, Republicans, independents, libertarians. It's a human right of self-defense. And it is also the central component of the Second Amendment, a right that is not given to us by any government. It is not given to us by any politician. It is bestowed upon us by our very existence as humans. And the Second Amendment doesn't give us that right. It simply recognizes that right. And the U.S. Supreme Court agrees with me, and they agreed with me in the case of the United States versus Heller, which, by the way, was reaffirmed in the case of McDonald versus Chicago, and reaffirmed 2 years ago in the case Catano versus Massachusetts. And Catano, which I think is very applicable to the question of a so-called assault weapon bans, said that any firearm that is bearable arms, is protected initially by the Second Amendment. And in Caetano, they dealt with a stun gun. And I can assure you that the number of people in the United States that own semi-automatic rifles labeled assault weapons far outnumber the number of Americans that own stun guns. And yet the Supreme Court found in that case that stun guns were in fact protected weapons or protected arms under the Second Amendment. Now, in fairness, the Heller Court did say there are certain types of weapons that can be banned if they are unusual and they're not typically owned by Americans for lawful purposes, if they're not in common use by Americans for lawful purposes. The Supreme Court said certain weapons are presumptively bannable. And the example they use, or one of the examples they use, is a machine gun, which unlike the semi-automatic gun, which is one pull of the trigger, one bullet fired, a fully automatic machine gun is you hold the trigger back, and as long as you're holding the trigger, that gun is firing bullets and reloading with one pull of the trigger. Much different than a semi-automatic, and the law recognizes this difference. So the question is, what are these Supreme Court cases mean for so-called assault weapon bans today? Well, before I answer that question, I want to talk for just a couple minutes about what is an assault weapon with a little bit more detail. Again, keep in mind this, and if you only take away one thing from today, this is what you should take away from this. When you see the words assault weapon, this is not a factual, denotative definition or term. This is a political propaganda label used by people that want to ban firearms. And I'll show you the specific evidence in about 30 seconds. You see, 30 years ago, and this is well established, this is not new information that I'm providing. 30 years ago, there was a gentleman by the name of Josh Sugarman who worked for a group called the Violence Policy Center. And he, give him great credit because what he did, really seems to, in many respects, worked. He said we should take advantage of the fact that an ordinary semi-automatic rifle, which happens to look like an M16 military gun, we should confuse these two in the minds of the public and others and just label them all assault weapons and blend them together to try to, of course, ultimately accomplish more gun control. And it was all turned on not how the guns operated, because these guns operate much differently, which the U.S. Supreme Court, by the way, has said unequivocally, these are different objects. These are essentially different weapons. In the case of the Staples versus the United States, 1994, the U.S. Supreme Court specifically held unequivocally that these guns were totally different from one another. And yet, because they look alike, so many people conclude that they're all essentially fall under the rubric of assault weapons. Now, just because something looks like something doesn't make it that thing, right? It's pretty common sense. Think about it. Just because something may look like a Rembrandt painting, right, doesn't make it an authentic Rembrandt. And I spend time in Times Square. Now, there's a lot of people in Times Square that dress in costumes of all sorts of superheroes. Ever see them on the TV? Ever see that in Times Square in New York City? I'm sure you have. Well, they dress as superheroes, so under the definition of what's going on here, because they look like superheroes, they would, of course, have superhero strength and X-ray vision eyesight. But, of course, that's absurd. In no other context would we say that because something looks like something, it is that thing. Well, that absurd context does exist in American life, and that's in the context of the political debate over assault weapon bans. Now, I should mention that the types of features that convert an ordinary gun into an assault weapon are, we'll just pick three. Now, the way these statutes generally work is this way, just generally, okay? All the statutes that ban assault weapons work this way. They say, okay, you start off with a semi-automatic gun that's a rifle. Then they say it has a detachable magazine. And all a magazine is that piece of plastic that you put your bullets in, and then you put the bullets into the gun. So you have a semi-automatic rifle with a detachable magazine that goes in the gun. Plus, the statutes will say, on top of that, you have to have one or more of the following features. And what are these scary features? What are these features that elevate an ordinary gun into an assault weapon? Again, these features are things like a pistol stock. Now, a pistol stock comes from a pistol. In Heller versus the District of Columbia, the Supreme Court said that pistols and handguns are protected by the Second Amendment. So adding a pistol stock to a rifle, how does that make something that's constitutionally protected into something that's constitutionally unprotected? It shouldn't, and I don't think it does. The second thing is a shoulder stock, an adjustable shoulder stock, or a telescoping shoulder stock. What do these words mean if you're not already familiar with firearms? Ever go and get new shoes, right? You see like 12 pairs of the same shoes, except they're different, ready? Sizes. All a shoulder stock does is it shortens or lengthens the rifle so that if you're a tall, big guy, you can have it one length, and if you're a short person, you could shorten it. So every reference to these stocks, adjustable, is talking about adjusting a rifle to your size, no different than a shoe size, and getting the shoe size right. How does that turn into an assault rifle? And there's others, but I love this one. I love this one. Most of the statutes that ban semi-automatic rifles say that if your rifle can accept a bayonet, if you have what's called a bayonet lug, which allows you to put a bayonet on the end of the rifle, it turns it into an assault weapon. Now, I don't know about you. I read a lot of papers every day, and I'm sure you all do too. It's been a long time since I read any stories about people getting killed with a bayonet on the end of a gun, but that's just me. Maybe I'm not reading the right papers. So, at most, these features, at most, make the guns more reliable and better for users to shoot accurately and more safely. So, at most, these actually improve the safety of the gun. They don't reduce the safety of the gun. But because of definitional games, the legislators in 6 states in the District of Columbia are able to ban these types of guns. Now, why are these laws justified? What is the argument in favor of these laws? Well, it's really quite simple. They say, well, you know, criminals will use these guns to do bad things, so we want to deprive Americans of our right to have them. So let's think about that logic. Or I like to say, let's think about that illogic for a moment. So our constitutional rights under the Second Amendment, this is not a made-up right based on penumbras and emanations, is it? It's actually in the text of the Bill of Rights, right? The Second Amendment is the Second Amendment of the Bill of Rights, our first freedom. And yet there are people out there that say, because someone may use these types of guns to engage in criminality, you and I, as Americans, have to give up our Second Amendment rights to have them. Now, there's something perverse and absurd about having our fundamental rights shrunk and reduced and lessened by virtue of the conduct of criminals and psychopaths. That is crazy that we should lose our fundamental constitutional rights by virtue of the acts of criminals and people that should be locked up in mental institutions. And the Supreme Court agrees with me in the Heller case, where they talk about the social dangers associated with firearms and said in the concluding paragraph of Heller that, you know, we understand the arguments about gun control, but there are certain policies that are, and I'm quoting the Supreme Court here, off the table because they've been removed from the democratic process by being in the Constitution. And gun control arguments are largely and should be off the table. For those people that want more gun restrictions, I have a suggestion for them. It's called follow what retired Justice John Paul Stevens advised. It's called amend the Constitution using Article 5 procedures. Don't try to subvert it in other ways that do not speak to the real will of the people. So how should courts apply the Heller test of common use to assault weapon bans? It's really very simple. Today there are at least 8 million AR-15s in American life. Well, there's somewhere between 5 and 8 million. You know, there's a debate about it, but it's millions and millions of people. And when you compare that to the number of people that engage in other lawful activities like swimming and jogging, you find that the number of AR-15s far exceeds many of those other common activities in terms of the participants. And the AR-15 is widely used for hunting, target competitions, and of course, commonly used for self-defense. So without a doubt, under the Heller standard of common use for lawful purposes, the answer is they would be well protected. So why are these 4 Court of Appeals cases essentially ignoring this? Well, one observation I'd like to make is keep in mind the states from where these gun ban cases arise: New York, Maryland, California, New Jersey, Illinois. So these are blue states, and when you take a case up to appellate judges in these blue states, where are these lawyers who have now become judges from? They're from the same blue states. You don't see assault weapon bans in so-called red states in Texas and Georgia and South Carolina so much, right? So I think that's part of the reason why no case is basically ruled in favor of knocking down assault weapons. Although there is cases that have ruled in favor of the Second Amendment, they've ultimately been overturned en banc by, let's say, the big Fourth Circuit. Beyond that, all of these cases essentially engage in forms of balancing of interest. They essentially take the Justice Breyer dissent that says we're going to weigh the good and the bad of guns and shake it all up, and then we're going to rule for the government. That's really what they do. And they just keep repeating the words assault weapon over and over and over in their opinions as if this is some sort of talisman for good constitutional reasoning. But in reality, it's not good legal reasoning, and I don't think it's consistent at all with the Heller case. I should also mention that in addition to Brett Kavanaugh, there are other judges who also agree with Kavanaugh's argument that these bans are unconstitutional, and that includes a Bill Clinton appointee, Chief Judge William Traxler of the Fourth Circuit, as well as Judge Mannion, a very well-respected judge in the Seventh Circuit. So Brett Kavanaugh is not out there by himself by any means in terms of where this jurisprudence stands. So I just want to address 2 more points before I sit down. The first is many people like to argue that the social consequences, the alleged social consequences of widespread gun ownership in the United States and these AR-15s and assault weapons or whatever we're going to call them, is that they're not protected because it hurts law enforcement and leads to murders and the like. But of course we know there's countless examples of other rights in the Bill of Rights that have arguably potential social consequences that you may not like. The Fourth Amendment, we'll just pick the Fourth Amendment. Now the Fourth Amendment says you are free from unreasonable searches and seizures and warrants and all those things. And there's many instances where the police, when they arrest a known violent murderer and rapist, they arrest the bad guy. And yet, because they screwed up the process of how they arrested him, how they got the evidence, how they put it together, guess what happens? That known violent criminal walks free. That is a social cost because he's not punished and he's walking the streets where he can do more harm. But we do not ignore and throw the Fourth Amendment out just because some criminal may walk free. That's not how constitutional law works. And my final point before I close is this. Many of these federal courts say, look, you don't need firearms, Americans. Don't be silly. We, the government, got your back. We got your back. We got the guns. We'll take care of you. You don't need the gun of your choice, and you don't need guns at all for that matter. My response, cue the laugh track. As a matter of theory, maybe the government has some duty to protect us. As a matter of American law, and you all are lawyers, you know this, as a matter of American law, There is no duty on the part of the federal or state or local governments to protect any of us in any respect unless narrowly you're in their custody. They have no duty. And in fact, there's countless examples of this every single day in American life. The phrase on the side of police cars, "to serve and protect," may be a nice slogan, but it's not the law of America. There is no duty to protect us. So I also will say that the reality is that police are usually not around when we encounter the criminal. I've made the point in my book, Duped, which you have, this. Police are not first responders. That is a myth. The real first responders in American life are you and me. We are the people that first encounter the criminal. We first encounter the fire. We first encounter the sick person. We first encounter the problem. And we either call 911 or maybe you don't have an opportunity, or you address the threat right there. And if you don't believe me, 1.2 million Americans every year are murdered, raped, or violently assaulted because the police do not arrive in time. And this is not because the police are bad. They just can't be everywhere at all times. So in the end, folks, whether you like it or not, the reality is we are our own first responders. And I would say that we thus have the right to the same protections as a law enforcement officer, including the right to firearms of our choice. I am urging now that the U.S. Supreme Court use its powers under the Constitution in Article 3. Remember, the Supreme Court is the one Supreme Court as defined by the Constitution. And to further monitor, police, and ensure that going forward, the lower courts, or under Article 3 language, the inferior federal courts, start to recognize and protect all Americans' rights to the Second Amendment, including those that have been deprived those rights in those states and the District of Columbia who have been denied the right to own an ordinary firearm in the form of an ordinary semi-automatic rifle with a few cosmetic features. Because it's wrong that people in 44 states in the United States have these rights, and you cross one border and having this firearm somehow turns you into a felon going to prison. There's something wrong about that, and I want the Supreme Court to step in and address this. Thank you.
Thank you, Mark, and thanks to the Federalist Society for hosting this important event. Before I delve into the assault weapon issue, I want to give some context on the state of gun laws in America. I think that's important. As Mark pointed out, assault weapons are generally permitted in the United States. They were banned under federal law between 1994 and 2004. That ban lapsed, and now they are prohibited in several states and allowed in the others. Under federal law in America today, there are no limits on how many guns you can purchase. You can purchase 50, 100, 1,000 guns at a single time if you choose. There are no limits on how many guns you can possess. You can possess all you can fit into your house. There are no limits under federal law not only on assault weapons, but under state laws, there are hundreds of models of conventional semi-automatic handguns, hunting rifles, shotguns that are available. So in every state, you can buy and you can possess literally thousands of semi-automatic handguns, rifles, and shotguns. Some other context is important. Guns are specially protected in ways that no other product or industry are in America. Guns are exempt, for example, from the Consumer Product Safety Act. So even if there are safety devices which would save lives of children and others and are completely feasible, would not affect the functionality of the gun in any way. With any other product, the government would require that those safety devices be put in. With guns, they cannot. They do not have that authority. That's thanks to the National Rifle Association influence on Congress when the Consumer Product Safety Act was enacted. The gun industry has special protection from civil liability. So some courts have held that when gun companies negligently supply criminals, for example, if they were with any other product, they could be sued negligence, but some courts have held because they are licensed gun dealers, they have no such protection, or they have no such liability. Gun data is prohibited in some cases from being disclosed to the public, even if there's no good reason to prevent the public from seeing it. And if guns in more hands led to less crime, the United States would be a perfect model for that, given that we possess such a vast number of guns, and yet the facts prove just the opposite. U.S. has gun death rates that are many, many times higher than the rest of the world for comparable countries. The gun homicide rate is 25 times higher than in other high-income nations. For example, Americans are over 50 times more likely to die from a gun than in the United Kingdom. Our crime rate, actually, is comparable, in some cases lower, than other high-income nations. So crime isn't the problem. The problem is because of the lax gun laws that I've summarized, our criminals have easy access to guns. One reason is another important part of American law, which is that federal law allows unlicensed people to sell guns without background checks. So if you get out of prison, you've been convicted of murder and served your time, you can go to a gun show, or you can go online or go to classified ads, find a unlicensed person, ordinary person who does not have a federal firearms license, and that person can sell you all the guns you want without a background check. We're trying to stop that at the Brady campaign. We're trying to require background checks for all gun sales, but under current law, that's the case. So even though our crime rate, as I said, is comparable, because it's so easy for criminals and other dangerous people to obtain guns in America, our gun violence rate is completely out of whack with the rest of the world as far as comparable nations. Every day in America, over 340 people are shot, 96 or so are killed by a gun, 47 children and teens are shot, 8 of them are killed. And evidence studies show that states with the most guns have far higher gun death rates than states with lower amounts of guns. If you're in a home with firearms, the risk of homicide, suicide, is several times higher than in a home without firearms. And while guns can and sometimes are used in self-defense, it is much more likely that guns will be used against family members, visitors, innocent people in suicide, unintentional shootings, or assaults and homicides. Now, most Americans today choose not to own firearms, even though they have a right to do so under the Second Amendment, as construed by the Supreme Court in Heller. However, many of these people are victimized as a result of guns that others choose to own. And at the same time, and this has some constitutional significance, our lack of gun regulation is not a product of public will. For example, over 95% of Americans support background checks for all gun sales. that may be the most popular legislative proposal out there in America today. I do not know of any legislative proposal for any issue that has the popularity of simply requiring Brady criminal background checks for all gun sales. And yet, it's not the law of the land. Basically, about everyone in America supports background checks for all gun sales, except the gun manufacturers who want to sell more guns, and the politicians and lobbies that support the gun industry. And that's important because the extreme, expansive view of gun rights is not wildly popular. However, it has undue influence in the legislature. Now, the issue we're discussing today is about assault weapons. It's not about whether Americans can or should choose to own firearms if they want. It's not about whether Americans can or should choose to stockpile an arsenal of semi-automatic handguns, rifles, and shotguns. They can do so under federal law and the law of all states. The question is whether it's constitutional for states and perhaps the federal government to restrict or prohibit the civilian purchase and possession of certain types of semi-automatic weapons, which, as Mark discussed, have certain attributes, such as rear pistol grip, barrel shrouds, ability to accept large capacity magazines, and others. So the argument really is, does the Constitution provide a right to these design attributes? Every single court that has considered this issue has rejected the position that Mark so eloquently made. And there are a number of reasons for that. One is that while Mark said that the features that make an assault weapon are cosmetic, that is simply not the case. They are functional aspects of the gun that make it easier to kill large amounts of people in a short amount of time. You don't have to ask me about that. You don't have to ask Mark about that. You can ask the relevant market, because the market has spoken on this issue. The market I'm referring to is the market of mass killers. People who want to kill as many people in as short a time as possible choose assault weapons and large capacity magazines overwhelmingly. The mass shootings in the high school in Parkland, Florida, in the church in Sutherland Springs, Texas, the music festival in Las Vegas, the mass shooting in San Bernardino, California, the elementary school at Sandy Hook in Newtown, Connecticut, the movie theater in Aurora, Colorado. All of those mass killers chose AR-15 style assault weapons and large capacity magazines. That is not because they liked the way they looked. It's not because they thought it matched their outfits. It's because they knew that they were effective in accomplishing their mission, which was to kill as many people in as short a time as possible. And the fact is that they were correct. And courts have recognized this. The difference, in fact, between a semi-automatic assault weapon and a fully automatic gun there are some differences. One is the automatic fire, but the difference is not that great. You can empty a 30-round magazine in about 5 seconds in a semi-automatic assault weapon. It takes about 2 seconds for a fully automatic comparable gun. 3-second difference. Courts have recognized that's not much. Now, we've had a ban, as I said, a federal ban on assault weapons before, and the results show that they saved lives. There are people who are alive today who probably would be dead if we didn't have that ban. Among other statistics, the ban had resulted in a 180%, according to one study, decline in gun massacres. That is, 6 or more people being killed. Over 200% reduction in people killed in those gun massacres. The decade before the federal ban, there were 11 gun massacres with 95 deaths. The decade after the ban, over 3 times the number of gun massacres and over 4 times the number of people killed in those massacres. And by the way, if anyone delves into this side of the argument, over 80% of the gun massacres took place in guns allowed zones, not gun-free zones. The constitutional issue we're talking about is not even whether you agree on an assault weapon ban. The question is, should legislatures be allowed to make the judgment that AR-15, the sorts of guns that these mass killers have chosen, and other similar weapons, should not be permitted by civilians, possession by civilians, and that they should be limited to amassing arsenals of conventional handguns, rifles, and shotguns. And to be clear, the Supreme Court in Heller did not suggest in any way that assault weapons are constitutionally protected. In fact, just the opposite. The majority opinion by Justice Scalia recognized that M16 rifles and the like, and I'm not quoting here, are not constitutionally protected. And I may have gotten this wrong. I thought Mark said that the Supreme Court in the Staples case said that these sorts of assault weapons are totally different from military M16s and others. That's not true at all. This is a quote from Staples versus United States, a Supreme Court decision in 1994. Quote, the AR-15 is the civilian version of the military's M16 rifle. So it's very similar, and courts have recognized it. The only major difference is that it does not enable automatic fire, but the other attributes are very similar. And that's why so many courts, every court, has correctly ruled that bans on civilian possession or purchase of assault weapons can be and should be held as constitutional. And I want to quote an opinion which makes this point much better than I could. by a conservative judge, Harvey Wilkinson, who actually was on Supreme Court short lists for Republican presidents in the past. And this is what he wrote in the context of upholding Maryland's ban on assault weapons and high-capacity magazines. Disenfranchising the American people on this life and death subject would be the gravest and most serious of steps. It is their community, not ours. It is their safety, not ours. It is their lives, not ours. To say in the wake of so many mass shootings in so many localities across the country that the people themselves are now to be rendered newly powerless, that all they can do is stand by and watch as federal courts design their destiny, this would deliver a body blow to democracy as we have known it since the very founding of this nation. He goes on, and I'm skipping some. Providing for the safety of citizens within their borders has long been state government's most basic task. In establishing the, quote, right of law-abiding responsible citizens to use arms in defense of hearth and home, close quote, Heller did not abrogate that core responsibility. Indeed, Heller stopped far short of the kind of absolute protection of assault weapons that appellates urge on us today. Let me close by pointing out another key point that I think we should all consider when addressing not just the constitutionality of assault weapon bans, but any Second Amendment issue. And that is that the Second Amendment cannot be viewed in a vacuum. I think Mark referred to the Second Amendment as our first freedom. I would disagree with that. I think our first freedom is our right to live, our right to safety, a right, if you will, not to be shot. And an extreme, expansive version of the Second Amendment infringes on that most fundamental right. Now, we have a gun violence epidemic in this country, which we should not tolerate. Mass shootings are a mere part of that, but an important part, because today many of us do not feel safe in high schools, sending our kids off to even elementary school, workplaces, shopping malls, synagogues, churches, and many more places where there have been gun massacres, mostly using assault weapons and high-capacity magazines. Now, there are common sense solutions which most Americans agree on that can reduce gun violence. Assault weapons is one, background checks is certainly another. And we should focus on those solutions, not on extreme readings of the Second Amendment, which claim a constitutional right to pistol grips, barrel shrouds, and high-capacity magazines. And we should all work together to try to save lives. Thank you.
Thank you. We're going to get to audience questions momentarily. We've gone a little bit long in opening remarks, but I do want to give time for rebuttals. So, Mark Smith, let's keep this to 3 minutes for each of you.
I'll just make a few quick points. First of all, Jonathan eloquently points out that there's a right to life, the right not to be shot, the right to safety. I think that's all generally true. Except the question is today, not do you have that right, but how do you effectuate and make that right real in the real world So I will ask you this. Is the way to really protect our lives and the lives of the people we love to depend upon the government like they did in Parkland, Florida, where Scott Peterson, the guard on duty, who's now lost his job essentially, right, because of what happened down there, refused to go into the school building and confront a shooter? Should we depend upon our lives by the other security guards at Parkland who, when the shooting broke out, one, ready, hid in a closet, one jumped on a golf cart and drove away? Do we want to let our lives be protected by the 8 police officers of the Broward County Sheriff's Department that set up a perimeter outside the school and never tried to confront the shooter and didn't go in essentially until the shooter left and ordered a sandwich at Subway at the local Walmart? Really? I agree we have a right to life, self-defense, and safety, and the way to get there is by letting private citizens own firearms. Second point, Heller said in the majority opinion that there are certain policy choices that the Bill of Rights takes off the table because they're fundamental constitutional rights. And one such fundamental constitutional right is the right to bear arms. So you can debate the merits of gun control all you want, but the truth is the way that should take place is in the context of amending the Constitution using Article 5 procedures and taking the Second Amendment out like John Paul Stevens recommends. But the gun grabbers don't want to do that. That's too hard and they don't have the support for it, so they try to subvert it, go around it. Third point is this, okay? The idea that mass shooters and remember, it's not about mass shooters, it's about mass killers. Did you know that the greatest number of school children killed in an attack, in a murderous attack, was done with a bomb in Bath, Michigan, close to the turn of the century? Not guns, a bomb. That's consistent with the people that used a truck bomb at the Oklahoma City federal building. Needless to say, the German pilot that killed 250 people by crashing his plane, the arsonist that killed 32 people when he set afire the upstairs lounge in New Orleans in 1973, the person that killed 87 people at the Happy Land Social Club in 1990. There's lots of ways to engage in mass killing without guns. Mind you, the Rand Corporation, and I'll just end with this, the Rand Corporation in 2018, now the Rand Corporation is based in Santa Monica, California. Don't think there's a lot of supporters of the Second Amendment out there, right? So the Rand Corporation specifically did a major study about is there any impact and effect on assault weapon bans on public safety, and they concluded there was no reliable evidence. That's the Rand Corporation in 2018. I think that says enough because, again, we can agree that the Rand Corporation, at least on this issue, can be deemed nonpartisan. Thank you.
Mr. Lally, 3 minutes.
Sure. First of all, most of what Mark was arguing about was whether private citizens should be allowed to own guns, which is the law of the land under Heller, that there is a right of law-abiding responsible citizens to have a gun in the home for self-defense, and we can argue about whether that should be expanded in some ways. None of that, though, is an argument of what Mark was talking about. None of it is an argument for a right to pistol grips, barrel shrouds, high-capacity magazines, assault weapons, which is what we're talking about. So it's really a red herring to talk about should there be a right to guns in some ways. It's an interesting topic. I'm happy to debate it, but that isn't what we're talking about here. As far as bombs, I mean, yes, there are many ways in which people can be killed. I don't know if we can argue about whether there should be a right to, or more regulation of bomb-making material. That's also not the subject here. The subject here is the fact that we've had a epidemic of mass shootings using assault weapons. That's a fact. the killer in Sandy Hook could have used a bomb, I suppose. He didn't. Killer in Aurora, Colorado, San Bernardino, Las Vegas, Pulse nightclub in Orlando, and others, they killed using assault weapons. And that's what we're debating here.
Very good. Let's move to the audience for questions. If you have a question, we use the floor mic, please. Let me just get us started really quickly. We've got about 20 minutes. I'm going to dig down, if we could, into this distinction between cosmetic versus non-cosmetic. One of you is insisting it's a cosmetic difference between assault weapons and non-assault weapons. The other's not. You've both focused on detachable magazines, although Mark Smith talks about detachable magazines, and Jonathan Lowy has referred to detachable high capacity magazines. Is there a real difference there between the two of you and how you're using the terms? And talk to me more about cosmetic versus non-cosmetic, if you would. And does the assault weapon ban, does it say more about the kind of person who's interested in these weapons? Is that what we're trying to regulate here? Somebody who, it reminds me of souped up cars. You know, they're legal, but they maybe say something about the kind of person who would buy a car and soup it up rather than just a regular standard sedan or something like that.
Well, you raise a good question. First of all, understand that really gun control is not about gun control. Gun control is, at the end of the day, about people control and what people do with these objects that are constitutionally protected. As to the definition of magazines, standard magazines for a handgun, you can have a debate about this, are basically for semi-automatic handgun, or about 15 rounds go into a magazine for a semi-automatic handgun or pistol. For a rifle that's semi-automatic, the standard magazine that generally comes in the box. If you buy one of these rifles in the box, you'll get a 30-round or 30-bullet magazine. These are standard. But given credit where credit is due, the gun control movement is very good at defining their terms in a way that captures the public messaging through the mainstream media, and labeling standard magazines as high-capacity magazines, which is really not accurate, is what they've done. So mechanically, those are the same, Dean, but from a PR propaganda point of view, decides to use different phraseology in talking about the same magazine.
Ms. Lowy.
Well, I mean, large capacity magazines are a big part of the problem, because if you can use a 30 or 50 or 100 round magazine, you can fire that many rounds without before you have to reload. And in fact, some mass shootings have been stopped at the time where someone has needed to reload. And if you have a 8-round or 10-round magazine, you're going to kill less people. And that's what the studies show. You kill more people when you use the high-capacity magazine. And to put that even more bluntly, that means if you were sending parents that were sending off their children to Sandy Hook Elementary to start their day at kindergarten or first grade, if there were only, let's say, 10-round magazines used, it is likely that some of those children would have come home alive, and they didn't, because of the large capacity magazine. So that's an important significance, and by the way, has virtually no legitimate self-defense purpose, unless your home is being assaulted by an army. And the studies show that it is, there's no evidence that I'm aware of that for civilian self-defense purposes, large capacity magazines are necessary. And then other things like barrel shrouds, which are, they enable you to hold the gun, particularly in conjunction with the rear pistol grip, where you can spray an area and again, to kill large amounts of people, useful for the military, also useful because with the barrel shroud you can, when the gun's heating up with this tremendous amount of fire, your hand is protected and it's shielded from the heat. So these are things that are put in for military purposes to spray an area of fire and have no legitimate self-defense purpose. And I quote here Republican Representative Brian Mast of Florida, was an Army combat veteran, and when he called for a ban on the sale of AR-15 style rifles, he said, the exact definition of assault weapon will need to be determined, but we should all be able to agree that the civilian version of the very deadly weapon that the Army issued to me should certainly qualify. And again, he has a lot more experience with those sorts of weapons than I think any of us here at the table.
Let me make one quick point and just slam the door on this myth. If you go to the Department of Homeland Security's documentation when they put out for bids, this is Department of Homeland Security, you go and see when they buy firearms, they buy personal protection devices, and this is in the book Duped if you want to look it up. They buy personal protection devices, and the definition of those are AR-15s that can also fire selectively, which means fully automatic, with all the different accessories and cosmetic features that are talked about in so-called assault weapon bans. So Department of Homeland Security views these guns as defensive, as does every police officer, because all the police cars in America have these guns with 30-round magazines in them for self-defense of police. I think we as citizens have as much right to self-defense as do people that work for the Department of Homeland Security and as do people that patrol our streets as police officers. So if it's defensive for them, it's defensive for me. It's not a weapon of war and mass destruction. It is in the hands of criminals, but that doesn't define the scope of constitutional rights.
All right, let's check in with our audience now. First question.
Hi, Amy Swear with the Heritage Foundation. This question is for Mr. Lowy. First a comment and then a question. So with regard to your last round of statements about these, quote, assault weapons not being defensive in nature, I took my mother to the range over Christmas break. She could hardly hit the target from 10 yards with a handgun. She could put, about 10 rounds in a fist-sized hole from about 50 yards out with a rifle. So if she had to defend herself, I think we'd both rather she had that rifle. With regard to the question, when you actually look at the number of firearm deaths every year, the vast majority of them are handguns, according to the FBI UCR. In fact, you're more likely to be stabbed to death or beat to death than you are to be shot to death with a rifle of any kind. Given that, and given that handguns are protected under the Second Amendment, even though they are responsible for the vast majority of firearm deaths, how would you then legally justify, on the basis of public necessity, public harm, some sort of banning of rifles that are not used for the vast majority of firearm deaths? Well,
I mean, handguns are much more popular than these assault rifles. So you would definitely expect there to be used much less frequently. And in fact, the mass shootings, I don't want anyone to feel that these mass shootings are a huge part of the gun violence epidemic in America. They aren't, as far as the numbers. They're horrific. They have, like other terrorist-type events, they have, I think, a greater significance than the actual death toll because they create fear in the community. So they're certainly very serious and horrific, and we should try to prevent them. But I agree that they're not, the death tolls in those mass shootings are not nearly as much as in more conventional arms. However, the fact is, as I say, these are firearms that legislatures have made the appropriate judgment have attributes that are useful for mass killing and not for ordinary self-defense. The handgun the Supreme Court in Heller held was the quintessential self-defense weapon in America. And therefore, the court held that it merited Second Amendment protection. At the same time, the court held that M16s and the like do not merit Second Amendment protection. The Supreme Court has said that AR-15s are the civilian version of the M16. That certainly is like the M16. And therefore, those sorts of weapons do not merit Second Amendment protection.
I disagree with your analysis, but thank you.
Anything from you, Mark Smith, on this point?
Well, look, certainly our society would be much more efficient in a criminal justice context if we did away with the right to trial by a jury, the right to, to make sure the police get a warrant before they search our cars and homes, and we're forced to testify regardless of a Fifth Amendment right to not incriminate oneself. It'd be a lot more efficient for the government to lock up a lot more criminals than they do today. But are we willing to make that sacrifice and throw the Bill of Rights out the window? And I say no. So all rights have consequences, but the Founding Fathers who structured the Constitution balanced this out back then, and they gave us recourse. If you don't like what's in the Bill of Rights, it's called amend it. But don't try to subvert it with backdoor state legislators, sneak it around through blue state judges to essentially eat away fundamental rights in the back door and not take on the question of amending the Constitution with Article 5 processes. That's not how you do it under American law.
Just briefly on that, I think that's an important point. I disagree with it, but I agree that it's an important point. And not to shamelessly plug my article, but I will shamelessly plug my article, article that I co-wrote with Kelly Sampson, The Right Not to Be Shot, Public Safety, Private Guns, and the Constellation of Constitutional Liberties. You can get it on a website near you. But it makes the point that every constitutional right is interpreted with an eye towards public safety. And it's true that the exercise of constitutional rights can endanger people and increase risk in certain ways. But at the same time, courts have placed limits on every right, First Amendment right, Fourth Amendment, every right, when there is a grave danger to public safety that would be, when it would greatly increase the risk to public safety. So, you can only take that argument too far, you can't take that argument too far that we just have rights, and if a lot of people die as a result, that's just the nation that we must live with. That just isn't the way the courts have interpreted any of the rights, Bill of Rights.
Let's take another question.
Yes, my name is Herman Bauma, and this is kind of following up on what was just said about other rights, including the First Amendment right. I understand the concern with the gun violence rate, and especially the epidemic of mass shootings. My question is for Mr. Lowy. I never quite understood why the gun control lobby doesn't also take a broader perspective and look at what's going on in our culture. And it seems like our culture, and to a large extent, is promoting and encouraging gun violence. When you look at so many of the Hollywood movies, I mean, and the TV shows and video games, I mean, they're all saturated with gun violence. It seems to me that should also be a concern. And yet I don't hear too often of people who want to deal with this whole gun violence epidemic. They're not suggesting that perhaps something should be done to curtail all the gun violence in our media and coming out of Hollywood and video games. It kind of seems to indicate the gun control lobby has more respect for the First Amendment than for the Second Amendment?
Well, I mean, the culture, Hollywood, music, books, it's pretty global at this point, right? I mean, you know, the people in London, Japan, elsewhere, I mean, they have violent video games, they have violent movies, they have violent lyrics in songs. They don't have anything like the gun violence rate that we have in this country. It's a pretty good experiment. Same access to all of that violent culture, no or very few gun deaths. And the difference is, it's because they have strong gun laws
I'm not sure
that make it
it's the
very
same
hard
access.
for dangerous people and criminals
Control
to
of
obtain guns.
television is a lot different.
Well,
In
you
Europe.
know, and I think that we can argue about whether if we rein in violence in movies and video games and what have you, that would also reduce gun violence. I personally don't agree with that, but I'm sure that there are some who do agree with it. That's a separate conversation. I don't think it makes sense to say we shouldn't do anything about the military-style assault weapons that are actually killing people and instead simply take some violent scenes out of movies. I mean, we can debate both issues at the same time. But I think if you look at what's going on in the rest of the world, you realize that gun laws, our weak gun laws, are the real problem.
Let me just quickly put to rest the myth that there is a gun epidemic in the United States. On page 84 of my book, Duped, all of which you have, you can look it up. The United Nations Office of Drugs and Crime did an international study. This is the United Nations, right? Also not the NRA. And they looked at the number of murders, which is the key, right? It's not gun death rates, because that includes 2/3 of them are suicides, right? But murder rates puts the United States as 90th in the world. That is behind the vast majority of countries in the Western Hemisphere. Ever notice how the gun controllers already want to talk about Europe? They never want to talk about the other countries in the Western Hemisphere, all of which ban guns. That's the Virgin Islands, Jamaica, Belize. Brazil, as you know, is now going back. Bahamas, Mexico, Puerto Rico, Dominican Republic, on and on and on. There are 89 countries that have essentially gun bans and yet far more murders than the United States. So this myth about international stuff is simply that. And of course, I have a simple test for anyone that wants to talk about more guns and less crime. You can come on up to where I'm from, which is New England, Vermont, Maine, New Hampshire, walk the mean streets of any town you want, anytime you want, with or without a gun, where there's guns everywhere, you'll feel very safe. Now you try that same experiment in the areas that are gun-free. Try it in Newark, New Jersey. Try it in Chicago. Try it in Baltimore. These are great gun control areas of the country. And let's take a look at the crime rates between guns are ubiquitous in northern New England and guns are banned in those cities that have massive amounts of murder every weekend. You can look up the numbers, you read the papers too.
Another question. Quickly, if you could,
Yes,
please.
to Mr. Lowy, I want to understand your position. The argument that the high-capacity magazines make the guns more effective and more dangerous, that would pass the reasonability test. But given that, why is it that the definition of an assault weapon requires both that and one of the other more marginal issues of a shroud or a pistol stock? Wouldn't you be in favor of just defining adding a high-capacity magazine? That makes it an assault weapon? Or any of these things instead of a combination?
Yeah, and let me ask a question this way. If you could ban just high-capacity magazines, would you settle for that?
Well, I don't know about settle. I certainly think
Is that the most important thing
I think
of all the
there
elements?
should be a ban on high-capacity magazines, period, separate from the assault weapon ban. I think that...
Is that the key element of assault weapons? If you could pick one element and get rid of it, would you get rid of high-capacity magazines? Or something else?
I think that's... I'm going to hedge some, but I think that might well be true. I think it's it may well be the most dangerous aspect of the assault weapon is the ability to fire large amounts of rounds in a short amount of time. And so having the high-capacity magazine is an integral part of that.
I just want to say the Parkland shooter used magazines that only had 10 rounds in it. So the Parkland massacre was conducted with a semi-automatic rifle, yes, but with magazines that only held 10 rounds. So, again, if it's good enough for the police, it's good enough for me.
And the Aurora shooter, I think, it had 75 or 100 round drum, actually.
And the Virginia Tech shooter had a handgun. The Santa Fe, Texas shot had a shotgun. The Annapolis shooter has a shotgun.
If you look at most of the mass shootings, I mean, there are some exceptions, but most of them you'll see either high-capacity magazines or assault weapons, and often both of them.
Okay, our lunch awaits, but let's see if we can get a final question, if you could be brief, sir.
My name is Jack Kneifel, and I really don't have a question as much as I do a comment.
Go ahead.
First of all, Mr. Smith, you brought up the term assault weapon and described it very thoroughly. I would like to mention to you that I have 69 years of personal experience in the firearms, sporting, shooting, and this type of thing, and considerable knowledge about the firearms industry. When a manufacturer comes out with a new weapon, they provide a model number or a label of some sort for it. But there is not one manufacturer in the world that has ever labeled their weapons assault weapons. That is a contradictory term that was developed 30 plus years ago by some bureaucrat or politician and has really become present day, and it's ridiculous. Secondly, Mr. Lowy, you indicated the issue today is assault weapons, okay? Using a strict interpretation of the English language, I have never seen a weapon assault a person.
Yeah, assault weapon is a term of art that's defined by legislatures. Well, that's what we're talking about. We're not talking about, you know, we're not studying poetry here. We're talking about legislation where assault weapon is a defined term, and that has attributes, including the attributes that Mark and I discussed.
Well, I'll give you
but I do want to, he's actually on, but the questioner is on to a good point in terms of American jurisprudence. Okay. Before about 30 years ago, if you actually look at the words assault and weapon together in American law, military is separate, that's the point, that's separate from what we're talking about. But if you look at the words assault and weapon in American law, you will find it in criminal court cases that say things like the defendant assaulted the person with a cane. Therefore, the cane was the assault weapon, and he has to go to jail. Or you'll see a baseball bat or a stick or a brick. So assault weapon, whatever a criminal defendant used to assault or beat up someone in a criminal case. Could be a car, could be a truck. So assault weapon was whatever was used to commit assault under the criminal law. About 30 years ago, the assault weapon phrase became a propaganda term, and frankly, given credit where credit is due, it's been extremely effective for the gun controllers, and I give them credit for capturing the language in a way that really does confuse people that are not familiar with how firearms really work and what they really mean.
Well, the language is actually, it's accurate, because as we've been discussing, these are weapons that are effective and have attributes that make it effective for mass assaults on people. They are not attributes that enhance self-defense protection.
Okay,
so actually the term, whoever made up the term, it makes perfect sense when applied to this class of firearms.
But that's not true, because the Department of Homeland Security, which is responsible for defending Americans, defines the AR-15 with extra features, even beyond what we can buy as civilians, as a personal protection device. That means self-defense. And the police carry these weapons to engage in self-defense and defense of others, because the police are not allowed to assault, the Taliban or anything. They're only using this defensively. So police and Department of Homeland Security says that these AR-15 style guns are defensive in nature, notwithstanding the fact that some kook or violent psychopath or murderer misuses them. They can misuse all sorts of other ordinary items, not just firearms.
Yeah, when we had a federal assault weapon ban, 1994 through 2004, law enforcement were in the lead pushing for that ban, because they were being outgunned on the streets. That period of time, so a lot of the drug gangs were using assault weapons, and law enforcement was facing them. It was, I think, more of that than the mass shootings that we've had more recently. So law enforcement certainly has been behind this, and when law enforcement carries weapons now, because of the increased militarization of the civilian firearms market, the law enforcement has needed to increase their firepower to match that. But the fact is, when law enforcement carries weapons, they're not doing it for self-defense in the context that the Supreme Court talked about in Heller, which is defending oneself in the home. They're doing it to protect public safety and take on bad guys who, unfortunately, sometimes have these sorts of assault rifles.
The legal definition of when self-defense is justified under American law is the same for you and me and police officers. You can use lethal force to save your life or the life of someone else. That's the same law that applies to cops who just happen to wear blue uniforms. And again, law enforcement does not support these so-called assault weapon bans. The people that happen to be law enforcement that support these are largely urban city police chiefs who get their jobs by virtue of working for liberal mayors in these cities. These same mayors, many of whom, of course, are in part responsible for the massive murders every weekend on their streets. And yet these police chiefs may have high profile on the cable news, talking head circuit, but that's not rank and file law enforcement officers who also have families they want to protect when they're not home. And needless to say, the efficacy of using firearms for self-defense is not lost on the police, and that's why they carry guns, and a lot more guns than we carry daily, and yet they patrol the same streets that you and I walk on, except we don't have the benefit of backup, radios, bulletproof vests, and the like, which they do.
Well, I'm afraid we're going to have to leave it right there. If you would please all join me in thanking our panelists.
Thank you, John.
And lunch is served.